We understand the difficulty that the NCE examinations present, and we help candidates overcome the obstacles and difficulties in understanding the course materials and examination formats. We do this through intensive classes, revisions, and examination review workshops. We do not believe in a one-size-fits-all approach, and our study sessions are focused on helping candidates understand the course material in a way unique and personal to them. In addition, we also offer private and intensive tutoring sessions for candidates who are in need of a direct one-on-one session. If you are interested in registering for our private tutoring session, please reach out to us via email at inquiries@ncaguides.com. Join me in welcoming your guide for this session. Thank you.
Introductory will commence the intensive class in another 2 weeks. The intensive class being offered by NCA Guides cover all the 5 core courses for the offered by the NCA. So each course will take about 4 sessions for each course, and there will be 1 class for exam revision for people writing the October examination. So I will hope to see most or all of you in our intensive classes, and we hope to benefit you in make the exam easy for you to pass. Very quickly, I'll be sharing my screen, because the approach we'll be adopting here is to go through the syllabus and sort of give an overview of each of the chapters. In foundations, let me just quickly share my screen now so that we can follow it. So these are foundations of Canadian law. In total, in foundation course, we have 10 chapters and about 35 articles that we'll go through. First, we'll start with the objective of the of foundation. First, I should say that if foundation is your first exam, it will make it easy for you to understand other courses, particularly courses like administrative law and constitutional law, because foundation touches a lot on those courses. If foundation is not your first exam, if you've written administrative law or constitutional law or criminal law, you will find foundation easy and very relatable as well, because it sort of covers a big aspect of constitutional law and administrative law. So the overview of the course is that it first of all gives you an overview of the Canadian legal system, and part of its objective is to introduce students to legal theories as they apply to Canadian law. It also acquaints us with the sources of Canadian law and the government of how the government's paraphernalia operates in Canada. So the executive arm, the legislative arm, and the judicial arm, and how they relate with one another. So we'll see under this in this course the different branches of Canadian government. We'll also get introduced to the treaty making process in Canada, and how the international law, what roles international law and treaty making plays in the context of Canadian law. And we'll also talk about the relationship of the Canadian state with the Aboriginal people. So we'll be asking questions around who are the Aboriginal people, what is their relationship with the Canadian state, what is the status of Aboriginal people, do they have a special status with non-Aboriginals or not, and the kind of struggles and that the Aboriginal people are faced over time, and how the Canadian state has tried to address some of these challenges in the light of its international obligations. So those are those areas we'll be covering under this introductory class. And when we come to the intensive class, we'll dig deeper into some of these topics and issues as well. So I start with basic theories of law, as we can see from my screen. So we'll talk about positivism and natural law. So what is positivism? What is natural law? And the schools of thought around that. So we'll be discussing legal theories as postulated by philosophers like John Austin, philosophers like Aristotle and Thomas Aquinas as well. What is the relationship between positivism and natural law? The positivist school of thought, for example, postulates that law is based on fact, what has been written. That is what law is. While the natural school of thought think differently, that law, there are a lot of factors that influence law. Part of it is our social values, part of it is morality. So in this course, we'll be looking at what is the relationship between positivism and natural law. What are the things that influence the enactment of laws? Why do parliaments, what are the considerations that they have before they make certain things law? So we'll be looking at all that in this course as well. And most importantly, we'll see at the end of the day that the objective of both the naturalist school of law and the positivist school of law is the same, because they are all aiming at achieving justice and equitable society, but it is just their means or their ways of achieving that justice that differs. And even at the end of this course, we will also see that they have both the positivist and the naturalist school of thought. They have more in common than we care to admit. So we'll go through the course and also see how they relate with one another. Another theory of law that we'll be looking at is the feminist perspective of law. So what does it mean? Basically, feminist perspective of law addresses how women have been disadvantaged over time. And if we look at legal history from across different jurisdictions, particularly common law jurisdiction, there were a lot of discrimination against women. Some jurisdiction disinherit women. For example, in Canada, in the case of Edward and Canada, the Senate appointment to Senate women could not be appointed into the Senate, while men could be appointed. So over time, there have been agitation from different quarters about this discrimination and how our perspective of law affects our treatment of women. So, and in the course of time, however, due to the agitations from different quarters, the court has interpreted, for example, that women, that the appointment of Senate, notwithstanding that the language of the act is masculine in nature, the courts, using interpretative skill, sort of cure this discrimination against women and say that language, notwithstanding that is masculine, it includes feminine, for example. So how we'll be looking at this in detail in the sense of how women have been discriminated over time and their struggles also to sort of achieve some form of social equilibrium, and the agitation towards social equilibrium as well. We also look at cases such as R. and Morgenthaler, where women have been prohibited, or where women in the past were prohibited from controlling their own body. So it's about abortion in the sense that they were required to get some certain form of approval from the government before they are able to carry out abortion. And over time, court has interpreted this kind of provision as being as infringing on the rights and liberty and security of persons of women. So how have the court, using various legal theories and using feminist perspective of view, have reinterpreted the law in order to ensure justice and equity for women in the society? We'll be looking at that as well. The other topic we'll be looking at is critical legal studies. What does it mean? What and how has the perspective of critical legal studies, how has it affected the formulation of law, regulation, and policies in Canada? Basically, critical legal studies also look at how our social environment, how our experiences, how our outlook towards life has sort of influenced the way we look at laws. A society that is chauvinistic, for example, will most likely enact a chauvinistic law. And a society that is more liberal and more accommodating of various sects of people will sort of enact a more liberal law, for example. So we'll look at this and see how it influences the enactment of laws in Canada. So we also look at law and economics, and in the sense that what is the interplay between law and economics. So how does economic theories influence the drafting of laws? For example, people use or legislature sometimes use theory of economic like efficiency to say before we enact law, we have to we have to examine the economic impact of that law. We also have to ensure that it achieves the greatest benefit to the greatest number of people. So how this consideration, how does it affect the enactment of laws in Canada in particular? We'll be looking at it. This chapter has 3 articles: analogical reasoning, legal positivism, and Arabs and Muslims. So in details, we'll look at these articles and how they help us to understand the theories of law. So for example, what does analogical reasoning mean? In simple terms, it is just the way the lawyer thinks. We might not know that is how we think, but when you read this article, you understand that the first. I'll give you an example. Sometimes we have a view of the law to say this is how the law should be, right? What informs those views? How did we come to that conclusion that this is how the law should be? It is through analogical reasoning. So it is the way that a conventional lawyer thinks is through analogical reasoning. He might not have the full theory of the law. He might not have the authorities to support his conclusion, but he analyzes that when you A plus A is this, then C should be this. That is what analogical reasoning tries to explain to us. So we also look at legal positivism. So we'll be looking at theories of philosophers like John Austin, Jeremy Bentham, and Joseph Raz, among others. How have they developed the theory of positivism? Earlier, we defined positivism that as the law in fact. And positivists say that the content of law depend on social facts and not on the merit. So you can have laws that are immoral. It doesn't make them not to be law. So it is what has been enacted by the parliament that is the law. But how did the parliament, how do parliaments come to determine what should be the law? So that is what the positivists try to explain, and also to sort of say that the before the parliament, there is a relationship between the law and morality and natural law as well. What informs the law is a number of considerations. So it is not just that parliament determine what should be the law or in vacuum. They contextualize it within the society that they live in, within their own experience and what have you. I will also look at the article Arabs, Muslims, human rights, access to justice, and institutional trustworthiness. So this access to justice is a very big issue in Canada, and this article chronicled the experience. We analyze about 13 cases and chronicle the experience of people and how their lack of trust in the system denies them access to justice. Because when people don't feel confident with the legal system, when they don't feel that they will get justice from the legal system, they ask themselves, why should I even approach the court when I'm sure that the system itself will discriminate against me? So particularly for immigrants, and you'll see that from the article, they chronicle the experience of particular minority group, the Arabs, the Muslims, and how human rights legislation in Canada has sort of tried to provide remedy for them. So, and the article talked about the experience of certain persons, and not that and conclude that notwithstanding the fact that there are human rights legislation that are available to protect them, these human rights legislations, they don't exist in vacuum. They have to be, in order to guarantee access to justice, they have to take into consideration the sociological experience of the those actors, of the people trying to access justice, in the sense that there are certain things that are things like discrimination, for example, and say the court should pay attention to things, the social markers for this minority group, and see whether the system has sort of provided enough guarantee to access to justice to them. Because if the people don't feel confident in the legal system, then they are never going to try to access the justice system. So we'll go to this, we'll examine all these articles in detail. Then the second topic is about indigenous peoples and the law. I will tell you that this is the first topic, and this topic are very important topic, and the NCA pays particular attention to them. And it's also important to note that in an exam scenario, the NCA is not going to ask a definition question and say, okay, define positivism or things like that. It will paint a scenario. It will be fact-based. It will paint a scenario, and it is our familiarity with these legal theories that will enable us to understand what the NCA is seeking to achieve. And we will need to make references to different aspects of the topic and the articles as well. They will assist us in understanding the or in answering the question. When I wrote my foundations, for example, one question that that the NCA asked is about access to justice, and we were asked to write a memo on the experience of certain minority group so that the memo should be written to our representative, so that he can present it before the parliament in order to amend the legislation in that regard. So you see that, I mean, they are not asking you to discuss access to justice as a concept, but in the memo you have to refer to the access to justice article, the experience of a minority group, and how the law can enable them to access justice through paying special attention to certain limitations that they have and sociological considerations as well. So going to the second topic, indigenous people and the law. Here we'll be talking about Aboriginal rights and title. What is Aboriginal rights, for example, or who are the Aboriginal people? The simple answer to that, I mean, the Aboriginal people are the people that occupied Canada prior to the European occupation, and they consist of the Indians, the Métis, and the Inuits. So, what are their rights? What rights do they have under the law, for example? So we'll be discussing like things like their cultural rights, their fishing rights, and what have you. And also we'll be talking about the title, the land. When the European took over their lands, what means did they use to take over their land, for example? So some were through treaties, and some they just took it over, just colonized their land. And how for those that were their land, where there was a treaty of protection and between them and the European. Over time, we also saw that the European did not honor this treaty. So, for example, in the case of Aran Siliboy, which we will consider in detail, there was a treaty between the European or the Canada states and the Aboriginal people guaranteeing their fishing rights. But this, in this case, the defendant was accosted by the government that it was violating certain laws, notwithstanding that was guaranteed in the treaty that that was signed with them. We also look at the discrimination against the Aboriginal people, in the sense that they were when they took over the land, when the Europeans took over their land, they were pushed to the margins, and the effect of the effect of that on them. Some of them, they were not allowed to practice their culture. They were taken to residential schools, and they were and sort of changed their orientation completely and made them lose confidence in themselves. So we'll also be looking at this kind of discrimination against the Aboriginal people, and also how due to international pressure, particularly international instruments like the UNDRIP, United Nations Declaration for the Rights of Indigenous People, which sort of is an international instrument which recognizes the rights of the indigenous people, and how those kind of instruments influenced the relationship of the Canadian states with the Aboriginal people as well. We'll also be looking at the effect of Section 35 of the Constitution, of the Constitutional Act 1982, which expressly declared that the rights of the Aboriginal people is hereby recognized and affirmed. So what does this mean? The right and title, what does the affirmation of the rights and title of the Aboriginal people, the affirmation, what does it mean? We'll also be looking at when Aboriginals, when there is an interaction between the government or the Canada states and the rights of the Aboriginal people, what are the things, what are the prerequisites that the government must observe? A very important case in this respect is the case of Aran Sparrow, which sort of stipulates the obligations of the Crown in Aboriginal matters. So we'll be looking at duties such as consultation. with the Aboriginal people. So if the government wants to take over their land or wants to do any acts that affect the intrinsic nature of the Aboriginal people, what does it need to do? So there has to be consultation, there has to be compensation, there has to be consent, there has to be concept like minimal impairment. For example, what does that mean? So how should the government relate with the Aboriginal people? So the RR and Sparrow sort of laid down the foundation for the dealing with Aboriginal people. Then we'll also be looking at what culture, what culture or what act of the Aboriginals will attract that Section 35 protection. Is it any kind of act of the Aboriginal people, or it has to be intrinsic to the nature of the Aboriginal people? We'll also be looking at that in details. There are a number of articles here. The Truth and Reconciliation Commission of Canada, which is about how, after a lot of negotiation between the Aboriginal people and the Canada state, the obligations that were imposed on the government in order to protect the Aboriginal people and recognize their rights, for example, is contained in that Truth and Reconciliation document. The article of John Burroughs, who is a foremost Aboriginal writer and thinker, talked about how the government can sort of recognize through legal instruments and the rights of Aboriginal people and protect them, not just by tokenism, but by actual and deliberate action protecting the rights of the Aboriginal people. So we also look at the United Nations Declaration on the Rights of Indigenous People, which is a United Nations instrument. The analysis of the UNDRIP, this sort of look at how the UNDRIP, how it relates to Canada, as based on, because there are constitutional guarantees for the rights of Aboriginal people. The article sort of argue that the constitutional rights under Section 35 of the Charter are sort of superseded the UNDRIP, and the way that the government of Canada has implemented that Section 35, there is no need for UNDRIP or implementation of UNDRIP in Canada as well. We look at Bill C262, which is a bill sponsored by a parliamentarian to sort of implement the UNDRP. So we'll also be analyzing the criticism of this bill. That is it even necessary? The implementation, will it complicate things further in view of Section 35 of the Constitution or of the Charter, so to say? We'll also be looking at I mean, there are about 3 or 4 articles on the UNDRP and the relevance in the in Canada. So we'll be looking at those articles one after the other. So there are a number of cases here as well, which we'll be looking at in details. Rio Tinto, which talks about when the duty of the Crown to consult, when does it arise? The case of Chippewas, which talks about who among the government, what is the appropriate authority that will carry out the consultation. So at the federal government level or at the provincial level, what is the appropriate authority that will carry out the consultation when the government is infringing or interacting with Aboriginal rights? We'll also be looking at the case of Mikisu and Canada, which talks about the duty to consult which says that the duty to consult does not arise in legislative matters. It's only in executive matters that it arises. So if the government or if the parliament wants to enact a law that affects Aboriginal people, does it have a duty to consult them? So this case tells us the answer. Then the case of Passion and Dean talks about what standard of review should we apply, should the court apply in reviewing Aboriginal matters? Is it reasonableness? Is it correctness? As in, what is the standard of review that is applicable in that regard? There are also a number of cases on Aboriginal title, Secotim Nation, proof of Aboriginal title, Daniels and Canada, who are the Aboriginal people, Brown and Canada as well. I will also look at the case of Aaron Marshall and Aaron Bernard. So we would we'll look at these cases together and see how it helps us to understand the relationship between the Canadian state and the Aboriginal people. Do we have any questions so far? Hello, are we there? Can we all hear me? Do we have questions so far?
Sir, we can hear you. No question.
Okay, thank you very much. So going to the third topic, it's sources of Canadian law. And like I mentioned earlier, Aboriginal, this chapter 2 is very, very important. And it's, I mean, year in, year out, it's the NCA pays attention to that topic because it's important for practitioners in Canada to understand the rights of Aboriginal people in the Canadian state. And similar to what I mentioned under legal theories, they are not going to ask a specific or direct question. It will be a fact pattern. So they can paint a scenario whereby the Crown sort of infringe on the rights of Aboriginal people, and they can ask you to identify some of the issues arising from there. So you'll be looking at whether there was a duty to whether there was a consultation, for example, or whether the duty to consult even arose at all, and whether for example, is it even an Aboriginal matter? Does it infringe on their cultural or intrinsic nature of the Aboriginal people? So you'll be looking at those kind of markers in order to answer the question. Going quickly to chapter 3, sources of Canadian law. Most of us that are from common law jurisdiction will see that, I mean, sources of Canadian law is very similar to our own sources in our jurisdiction as well. So the received English law, for example, the common law, equitable doctrines, and what have you. The significant difference between Canada and most other common law jurisdiction is that Canada is a mixed law jurisdiction in the sense that we have the civil code, which operates in Quebec, and we have the common law, which operates in other provinces. Common law operates at the federal level and at the provincial level, except in Quebec. Another source of Canadian law is we've seen it's listed here, statutory, which is law enacted by the parliament or by the legislature. where the matter falls within the jurisdiction of either the parliament or the legislature. So international law as well is a source of Canadian law, and we'll be looking at the treaty process and what have you. I mentioned earlier how Canada is a mixed jurisdiction, so that's what bijuralism speaks to. What is bijuralism and how does it operate in the Canadian context, and what is the relationship between the civil law, which is operational in Quebec, and common law, which is operational at other provinces. It's also important to note, for example, that common law operates in Quebec, notwithstanding that Quebec is a civil law jurisdiction. Common law, we mentioned, that operates at the federal level, and federal level applies throughout Canada. And to the extent that Quebec is a part of Canada, so it's going to also operate on common law where applicable. So how do they relate with one another? We'll be looking at this as well. There is the article on some thoughts on bijuralism, so which will be taking us through what is bijuralism, what is the difference between common law and civil code. Is there even a difference at all? We'll be looking at this as well. We'll also be looking at a number of cases here, Grimard and Canada, then precedents revisited, that's Qatar and Canada. So this article talks about how what do we understand by judicial precedent in the first place? Does anybody want to speak to that? Judicial precedent? Please go ahead, Mike.
Oh, okay. Well, precedents, it refers to, I believe, to the past judicial decisions and the ratios, the principles laid down in the judgments by the court.
Right. Thank you. That's useful. Any other taker? Any other taker, please? Judicial precedent. Okay, so I'll just continue. So judicial precedent is basically what Mayank mentioned, that a lower court is bound by the decision of a higher court. In this case of Qatar and Canada, we'll be looking at vertical precedent and horizontal precedent. So the vertical precedent speaks to the fact that a lower court is bound by the decision of the higher court, while horizontal precedent talks about court of coordinate jurisdiction who should follow the decision of one another. But there are instances where a lower court can refuse to follow the decision of a higher court. What are those instances, for example? I mean, most of us from common law jurisdiction, we find this very strange. But in this article, it talks about circumstances or situations where a lower court can refuse to follow the decision of a higher court, or a court of coordinate jurisdiction can also refuse to follow the decision of another court of coordinate jurisdiction. So we'll be looking at that as well. So we'll also be reading the article of equity is not a single thing. We mentioned among the sources of law that equitable doctrines are part of the sources of Canadian law. So there's this cliche that equity is whatever the Lord Chancellor thinks. In this article, we'll be examining that concept. That what does equity mean? Is it one thing? Is it whatever the Lord Chancellor thinks, or it means some other things? We'll be looking at that as well. So we'll also be looking at conscience as the organizing concept of equity. What is the role of conscience in equity, in formulation of equitable doctrines? So like I mentioned earlier, is it correct to say that equity is just according to what the conscience of one person, or there are other considerations to equity? So the article argues, for example, that equity is objective and it is not subjective. That what equity actually does is to measure the conscience of a particular individual against an objective equitable standard. So we'll be looking at these articles in detail as well. So the role of equity or equitable doctrines in as a source of law. So we'll also be looking at the article on the role of domestic courts in treaty enforcement and formulation. Who enters into treaty? Is it the legislature? Is it the executive? Is it the judiciary? Which arm of the government is responsible for entering into treaty? Because what is the process of making a treaty applicable in Canada? For example, are there some legislative process that needs to be taken? For example, if we mentioned earlier that the court recognizes international law as a source of Canadian law. If the relevant arm of government did not domesticate a treaty, for example, can it still apply in Canada? We are going to be looking at this as well. Then judgment, what is the status of judgment of international tribunals in Canada? So if we have a case or an issue that has been decided by an international tribunal, can a Canadian court apply that decision in a Canadian matter? We'll also be looking at that in this article as well. So a number of cases here, I think there are about four cases actually here, Greenfield and Canada, which talks about the role between common law, the relationship between common law and civil law in interpretation of statutes. So if how using common law doctrines and civil law doctrines as well, how the courts arrive at or interpret the statutes. Tan and Canada talks about horizontal overruling, how a court of coordinate jurisdiction can override or can refuse to follow the decision of another court of coordinate jurisdiction. Then Baker and Canada, will see it elsewhere, but in this instance, its relevance is in relation to international law. What is the place of international law under Canadian law? In decision of international courts or international tribunals, are they of binding authority in Canada? So basically, that's what the sources of Canadian law talks about, and it's also a very relevant topic to pay attention to, particularly the areas of the role of equity or equitable doctrines, and how how bijuralism operates in Canada, and what have you. We would talk more about bijuralism, I think, in chapter 9 as well, where where we analyze how in interpreting statutes, if a civil code says one thing and common law says something different, how do they marry? How does the court marry the interpretation of the two laws? Any questions so far before we proceed to the next chapter? Hello, Farhana, are you with us?
Hi, yeah. It seems good so far. Thank you.
Okay. I mean, feel free to butt in whenever you feel it is necessary to, so that, I mean, like I mentioned earlier, we need to make it interactive. Let it not be one way, so I can feel that you are following me. Thank
Sure.
you.
Thank you.
So the chapter 4 talks about fundamental principles of the Canadian legal system. What are the principles? So first of all, the starting point is the Constitution of Canada, and we know the Constitutional Act of 1867 and the Charter of 1982, which is all and there are other annexures to the Constitution as well, other laws that are part of the Constitution. For example, the Supreme Court Act is part of the Constitution. So when we go through the Constitution, we'll see some of these other laws that are part of the Constitution. So principle of undermining public law. These are unwritten principles of the Constitution, and this is how the court usually applies this principle in interpreting the public law, or in particular the Constitution and the Charter. So the first principle is rule of law. What does rule of law mean? I mean, does anybody want to tell us what rule of law mean? Rule of law, what does it mean to you?
I think it means supremacy of the law.
Yes, correct. Supremacy of the law, yes. Any other perspective? Any other perspective?
It is where all the other institutions are accountable to law.
Other institutions are accountable to the law. Absolutely correct. Any other perspective? Okay, thank you both. I'll just continue. So yes, as stated, that the law is supreme. Everyone is subject to the law, and there must be existence of a legal order within the state. So the Canadian legal system operates on the assumption that every issue should be governed by law. So whether it is governed by statutory law or the common law. So it envisages that every matter should be regulated by law in one way or the other. I will look at the case of Manitoba language reference, where there was a law that all laws in Manitoba should be written in both French and English. For a very long time, the Manitoba provincial government did not translate the law to French. It was only written in English, and this action was challenged, and the court said that, look, I mean, the law, to the extent that it has not been complied with, it is unconstitutional and is invalid. But the courts recognizing rule of law, that the state cannot operate in a vacuum and there must be a legal order in existence and at every point in time, suspended the operation of that judgment to allow time for the Manitoba government to translate the English laws into the French version. So this it used the principle of rule of law to arrive at that decision, because it recognizes that there must be a legal order at every point in time. So we'll be looking at this in greater details, what the rule of law means. Constitutional supremacy, what does it mean? So basically looking at the Constitution as the ground norm of the land, such that every other law is subordinate to the Constitution and they must comply with the Constitution. So in interpreting a law, the courts will interpret it in such a manner that it conforms with the Constitution based on the principle, based on the unwritten principle, underlying principle of constitutional supremacy. And we can see that Section 52, for example, talks about the supremacy of the Constitution, and also that's part of the fundamental principle of the Constitution is that amendments can only be made following through special procedure. So the Constitution is not amended in the way your regular laws are amended. Also, the Constitution, an unwritten principle of the Constitution, is the protection of minority, for example. So these are some of the concepts that we would be looking at as well. Another principle is parliamentary supremacy. So what does it mean? We often hear that Parliament is the most supreme organ of government, and it can enact good or bad laws. What are there any restriction to the ability of Parliament to enact laws? We'll also be looking at parliamentary privileges as well. What does it mean? I mean, what is the what are the areas that are covered by parliamentary privileges? Maybe someone should talk us through parliamentary privilege. What does parliamentary privilege mean to them? Any taker, parliamentary privilege, what does it mean? Randy, do you want to try? Hello, Randy, are you there? Does anyone else want to try? Yeah, go ahead, please. Farhana.
Yes. Well,
oh, sorry.
No, please go ahead.
Oh, thank you. It refers to the privileges and immunities by the members of the parliament.
Right, that's correct. Privileges of the members of the parliament. Any other perspective? Mayank, you can go ahead, please.
Yes, it refers to the like the immunities or any actions or any like expressions or speech which has been made within the parliament, that cannot be challenged before the court of law, or like they have some privilege that they can do some things in exercise of their functions.
Right. Thank you very much. That's very useful. So that's what parliamentary privileges is about. So the authority, because the parliament is seen as the legitimate body for to hold public power. So it is not because, I mean, in Canada, for example, where we run a parliamentary system of government, the people that are elected is the parliament. So the judiciary is not elected by anybody, and the source of the parliament who represent each different areas of Canada, they are seen as the actual representative of the people. So the parliamentary privilege sort of protects them to be able to function effectively and represent the people efficiently. So what are the areas that are covered by privilege? So if a parliamentarian, if the parliament, for example, unlawfully dismisses an employee, is it covered by privilege? For example, if a parliamentarian commits, if he defames someone outside the function of his office, is this something that is covered by parliamentary privilege, for example? So we'll be looking at the existence and extent of parliamentary privileges. What are the areas that it covers? We'll also be looking at so we'll also be looking at federalism. So what does we know that Canada is a federal state in the sense that power is divided within the federal government and the provincial government. So what are the powers that have been allocated by the federal government, and what are the ones that have been allocated to the provincial government, and who holds residual power in Canada? Is it the federal government? Is it the provincial government? Which body of the government has a residual power in Canada? We'll also be looking at separation of powers. In our various jurisdictions, we might be familiar with how judicial power resides in the judiciary, executive power resides in the executive. If we operate a presidential system of government, for example, we see how powerful the president can be, and the legislative power resides in the legislature. In Canada, it's a bit different in the sense that there is no strict separation of power between the executive and the legislature. So the prime minister, for example, is the head of government, is the head of the cabinet, and there are cabinet ministers who are also members of the legislature. So how do they operate? I mean, as executive and at the same time as legislature. So how does this affect the separation of power principles in Canada? We'll be looking at that as well. We'll also be looking to do an overview of judicial independence. What does judicial independence mean? It's stated that judicial independence is critical, is at the center of separation of power in Canada. It is the ability of the judges to make a decision or to interpret the law without interference from any arm of the government. So we would be we'll be looking at this in details as well. We'll also be looking at convention. What is the state, or what is the status of convention in Canada? So, for example, the Constitution provides that certain powers to be exercised by the Governor General, for example. So how does what influences how the Governor General enacts or exercises those powers? it is convention that dictates how the Governor General exercises the powers that have been he or she has been given in the Constitution. So we'll be looking at convention as well, and its place in the Canadian Constitution. So we'll analyze the case of Singh and Canada in details. So the case talks about judicial independence, parliamentary privilege, and separation of power. So basically all the principles underlining public law in Canada are discussed extensively in that case, and we'll be looking at it together. So in an exam scenario, for example, they are not going to ask you to define any of this concept. It will be hidden in the factual question that will be given, that you will be given, and they will, for example, they can the examiner might want to know whether a power that has been exercised by a provincial government is lawfully exercised by that provincial government. Does it fall within the power of that provincial government as contained in the Constitution? They can also ask questions around action of a parliamentarian. So I gave example of where a parliamentarian defames someone, whether he is covered by a privilege. So there might be a question around that, and they will the examiner will be trying to seek how deeply you understand privilege and what are the parameters covered by parliamentary privilege as well. So we go to chapter 5, which talks about parliament and the components. Parliament and the components. So the monarch and the governor general. So the head of government in Canada is the queen, and the queen exercise, or the king, as the case of the UK, as the case may be, and that power is exercised through the governor general. So how is the governor general appointed? What is the procedure for appointing the governor general? We'll be looking at that as well. The Senate, and also we'll be looking at the functions of the governor general. So the executive function of the government is exercised by the governor general. But as I mentioned earlier, by convention, the governor general only acts according to the instruction of the cabinet. What happens where a governor general refuses to follow the instruction of the cabinet? What happens? Is that law? I mean, if a law has been passed, for example, and the governor general is required to sign that law or on behalf of the queen, and the governor general refuses to sign, can he refuse, or can he or she refuse to sign? If he or she refuses to sign, what will happen? So we'll be looking at this scenario in the course of the classes as well. We'll also look at the Senate. We know that in Canada, the Senate is unelected, so in the sense that they are appointed by the Governor General. How does the Governor General appoint this Senate? We'll also be looking at it as well. What is the role of the Senate and the controversies around the unelected Senate? For example, in Alberta, a law was passed which tried to sort of democratize the appointment into the Senate. So it provides that the region or the province will do an election, will conduct an election, and after it might have conducted an election, it will submit the name to the Governor General or to the cabinet to recommend that name to the Governor General for appointment. So how valid is this? Is this constitutional, and did that law withstand the test of time? can the cabinet or the prime minister refuse to be bound by the persons elected by the provinces? So we'll be looking at these nuances as well. We mentioned under chapter 1 how previously female could not be appointed into the Senate because of the language of the Constitution, which gave the impression that it is only male that can be appointed into the Senate. So we'll be looking at the case of Edward and Canada and how the law was reinterpreted, the principle of the living tree, where the Supreme Court held that the law should not be left in the Museum of Antiquities. It should be modernized to take cognizance of the social realities of the time. So we'll also be looking at that as well. So we'll also be looking at the House of Commons, how they are elected, and we'll be looking at the concept of voter parity. What does voter parity means? We'll also be looking at who can participate in an election. In Canada, do we have can independent candidates, for example, participate in election? We have that in other jurisdictions. But what is operative in Canada, we'll also be looking at that as well. So there is the article on reforming the Senate, frequently asked question. So there is a lot of controversy around the Senate in Canada because it is an unelected body. So question about why it should be reformed and what if it should be reformed, how can it be reformed? We'll discuss a challenge on the appointment of senators and how the court held that anything that will that the constitution of the Senate is part of the constitution, and to amend that constitution of the Senate requires a constitutional amendment. So how does it relate with one another? We'll be looking at this as well under chapter 5. So quickly, we go to functions of parliament. We've mentioned some of them. What are the functions of parliament? Who summons the parliament? Is it the prime minister, for example? But after the dissolution of the parliament, there is no parliament in place. So how can it be the prime minister that will summon the parliament? So who is the appropriate authority that summons the parliament? We'll be looking at that as well. So we'll be looking at prorogation. What does prorogation mean? If we've been following Canadian politics, we'll know that I think about 2 weeks ago, the Prime Minister Justin Trudeau requested the Governor General to prorogue the Parliament. So what does prorogation mean? For example, can the Governor General refuse to prorogue the Parliament, for example? And if in the case that the Governor General refuses to follow the instruction of the Prime Minister in proroguing the Parliament, what will happen in that scenario? We would be looking at that. Another function of the Parliament is dissolution. So what is the lifespan of the Parliament? Does anybody want to answer that? Lifespan of the Parliament. Leonora, do you want to try?
I could, but I mean, I'm not sure.
It's fine, no problem.
So what I have back in my country will be what the Constitution says is the term of office of the president. So it sort of runs alongside that.
Which is how many years?
For us, it's 4 years. So every 4 years, we elect new parliamentarians and a president.
Right. Someone else want to try?
Is it 5 years?
Correct. So 5 years. The maximum lifespan of the parliament in Canada is 5 years. But must the parliament be operational for 5 years? No. The parliament can be dissolved before 5 years, but the maximum tenure of the parliament is 5 years. So in an exam question or exam scenario, for example, because the NCA can ask short answer question and long answer question that requires analysis and what have you. So this is an example of a short answer question to say where the lifespan, the maximum lifespan of the parliament. We'll also be looking at concepts like such as vote of confidence or vote of no confidence. So what is the implication of passing a vote of confidence or vote of no confidence? For example, where we talked about dissolution of or prorogation of parliament earlier. In the case of dissolution, if the prime minister asks the governor general to dissolve the parliament, can he refuse to dissolve the parliament? For example, we'll be looking at that. We'll be seeking to answer that question as well. So key actors, another thing we'll talk about is key actors in the parliament. So we'll be looking at political parties, and we'll be looking at the speaker, the function of political party and the function of the speaker. I mentioned earlier, or I asked earlier, if you can have independent candidates in Canada. Does anybody have an answer to that? Can you have independent candidature in Canada? Janine, you want to try? Janine, are you there? The answer doesn't have to be correct. It's just let's get a feel that we are all together and we are participating in this class. Hello, Janine, are you there? Ifeoluwa, do you want to try?
I think it's possible. I think it's possible we have an independent candidate. I'm not sure though.
Okay, that's fine. Anybody else? Okay, so I'll just answer the question. No, you cannot have independent candidates in Canada, in participating in election in Canada. You have to be sponsored by a political party. So what are the rules of political party in Canada? We'll be looking at that as well. We'll also be looking at the speaker, the function of the speaker, who is a very critical office holder in the legislature. So he heads, the speaker heads the legislature, while the prime minister is the leader of the party and heads the executive, the cabinet as well. We'll also be looking at parliamentary procedure and lawmaking. So how does the parliament operate? So it basically operates through committees. When the parliament is part of the definition of prorogation is the division of parliament. When the parliament has been summoned, it is prorogued and divided into various committees to perform its action. Under this as well, we'll be looking at parliamentary privilege in details, in greater details. So concept as what are the things that determine parliamentary privilege. So concepts such as rule of recognition and rule of necessity, we'll be looking at them in the course of the class as well. So what are the, for example, does a parliament, is it obligated to pass a fair law? can it pass a draconian law? Can it pass a retrospective law, or it must pass a prospective law? I want us to discuss that as well. Can the parliament, does the parliament owe the populace a duty of fairness in passing law? Can it pass a retrospective law? Does anybody have a view on that? Can the parliament pass a retrospective law, for example? Yes, Mayak, you can go ahead, please.
Oh, okay. So generally, the parliament cannot. It is the duty, like they have to make the prospective laws, but I believe that under certain circumstances they can, but I'm not sure what circumstances are those.
Okay, thank you. Any other taker? Ifeoluwa, you wanted to speak.
Yes, I wanted to say that in areas of criminal law, the parliament cannot pass retrospective law.
Okay, what of other areas? Civil law?
Maybe civil law, but not criminal.
Can they pass retrospective civil law?
I think someone said that. I don't know. I think so. I think as regards civil, they can, but not criminal.
Okay. Yeah, you're absolutely correct. So parliament cannot can pass retrospective civil law, but cannot pass retrospective criminal law. So those are some of the points that we need to note, and which speaks to the sovereignty and supremacy of the parliament. So generally, the parliament is sovereign and supreme, except as constrained by the constitution. So anything that the constitution did not say is unconstitutional for them to do, they can generally do it as part of parliamentary sovereignty. The parliament is sovereign. I think we talked about that under chapter 5, but we say that individual parliamentarians, are they sovereign? They are not sovereign. So they are also bound by the concept of rule of law and the law of the land as well. So we'll be looking at, we'll be examining 3 cases here, Duffy and Senate, which is about disciplinary measure taken by the Senate. We'll also be looking at Shagnon and Syndicate, and Singh and Attorney General as well. So the powers of the parliament to exclude strangers from its proceedings. So we'll be looking at those areas in greater details in the course of the class as well. Again, this is a very interesting topic in foundations, and it is something that we should pay attention to, that the examiner usually is interested in. Do we have any question so far? Janine, I want to hear your voice. Are you there? I just need you to say you don't have question or you have questions. So are you there? Okay, I will assume that Janine is not part of the class. Okay, so we'll look at, we go very quickly to chapter 7, which talks about, so we've talked about the parliament, the structure of the parliament, the functions of the parliament, the privileges of the parliament, and let's now go to another arm of government, which is the executive. The executive and its functions. What are the functions of the executive? They are the most visible arm of the government, in the sense that they control most most areas that you and I will be relating with in Canada. So part of their functions is rule making through delegated legislation. Generally, the power or the function of lawmaking resides in the parliament, but the parliament cannot envisage everything, right? So they sort of give the executive what we call delegated legislation to also proper functioning of the state. So what are the parameters? And is it everything that can be delegated? What is the role of the concept of delegatus non potest delegare in Canada? What are the confines or the limits of the legislature or of the executive in the under delegated legislation? We look at that as well. Another function of the executive is dispute resolution. So Human Rights Commission, for example, is set up by the executive. And what does the Human Rights Commission do? Try to sort of resolve administrative law issues. So what are the extent or limits of the executive in this regard? The another function of the executive is the determination of rights and obligations. So, for example, if you want to get a driver license, for example, you will have to go to the licensing office, which is established by the executive. For those immigrating to Canada, they will have dealt with the immigration office. That is also a function of the executive, because the IRCC that is established by the executive. So they determine who should be given refugee status, for example, who should be given a permanent resident, and who should be given citizenship as well. So those are part of the functions of the executive. Another function of the executive is the enforcement. So we an area that they are very common or very apparent in Canada is when we are driving, maintaining traffic laws. In Canada, we see the police a lot, ensuring that people observe traffic regulations. So that's also part of the function of the executive. The executive also provide services such as education. So the various provinces, they have their education board, for example. So that kind of a body is set up by the executive. So we'll be looking at those functions in detail as well. Where do the executive, source of executive power, where do the executive derive their power from? I want us to also try, where do they derive the executive, where do they derive their powers from? Any taker? In Kiru, the executive in Canada, where do they derive their power from?
Sorry, from the statutes.
From the statutes, okay. That's fine. Any other taker? Farhana? Farhana, are you with us?
Hi, sorry. Yeah. From the Constitution.
From the Constitution, that's correct. So the executive, they derive their power from the Constitution. So if you look at the Constitution, it clearly states that the executive power shall be exercised by the Governor General. It clearly states that. So the function, the executive function, is derived from the Constitution principally, and the second source of their power is the prerogative. So what is prerogative power, or what are prerogative powers, for example? So they are the residual power that has not been assigned to any arm of the government. So we know that the Constitution established the executive, the legislature, and the judiciary. So any power that has not been allocated to anybody among the or between the legislature and the judiciary is covered under prerogative, and is exercised by the executive. Under the executive power, how does the executive exercise its powers? So it is through different institutions. We talk about Board of Education, we talk about administrative bodies like the Human Rights Tribunal, we've talked about the licensing offices and what have you. We've talked about immigration and what have you. So it establishes the executive, the cabinet establishes different board to exercise those powers that have been conferred on it by the Constitution. Of course, the administrative body, how do they also exercise those powers? So they exercise it through civil servants. So what are the characteristics of a civil servant? Can a civil servant participate in politics? For example, we'll be looking at that. Civil servants, they have three major or significant characteristics. One is a ministerial responsibility. The second is political neutrality, and the third is public service anonymity. So what does all these concepts, what do they mean? So if you say a civil servant should be neutral, for example, does it prevent the civil servant from participating in politics? I want us to answer that as well. Can a civil servant participate in politics? Can a civil servant criticize the government of the day? Any volunteer? Yeah, Ifelua, go ahead, please.
I think it means that they shouldn't take sides with any particular government. They have to be neutral. I think that's the idea of the neutrality, that they can't be in favor of one, or let's say party against the other.
That's correct.
Yeah,
that's correct. Thank you very much. Can they criticize the government? Okay, we lost the fellow. Any other taker? Can civil servants criticize the government, for example? Miyank, do you want to try?
No, I'm not sure about that.
Okay, that's fine. Thank you. Leonora?
I think they shouldn't be allowed to criticize the government, because then it would appear to be biased towards one political party or another. So if you're supposed to be neutral, then overtly you should portray that neutrality. But if you end up criticizing others, then somebody might think you're for one party or another. So I guess they shouldn't be allowed to.
Okay, thank you. Farhana, do you have a different perspective?
I agree with the idea that government servants shouldn't be allowed to criticize the government because it might have an adverse effect on the decisions of the government itself. I'm not sure though.
Okay, thank you very much. So in Canada, for example, the restriction relates to senior civil servants. So they don't pay attention to junior civil servants in terms of criticism. So a junior civil servant can pass adverse comments against the government, but a senior civil servant is being held in Osborne and Canada that it will be against the principle of neutrality for a senior civil servant to viciously criticize the government or to actively participate in politics. So the restriction is sort of on senior civil servants in Canada. So another question that we might want to know is we've talked about federal government and provincial government as the various levels of government in Canada. We also have city municipalities. So in Alberta, for example, we have City of Calgary as at the municipal level. Are municipal governments, is it a separate level of government, for example? So those are some of the nuances or tricky questions that the examiner might want to know, to see if you have gone through the course content and thoroughly understood it. Here the case of, we'll also look at the cases of Tesla Motors and Ontario and Toronto City and Ontario. So it will help us to answer that question of whether municipalities are another level of government. And it will also tell us the actions of this executive. Are they reviewable by courts? What actions can be reviewed by the court? Is it all the actions of the executive that can be reviewed by the court? What are the parameters? How do we know which actions are reviewable and which actions are not reviewable by the courts? Very quickly, we'll go to Chapter 8. Chapter 8 talks about the structure of the Canadian courts. How are they structured? Does anybody want to tell us? It's similar to what we have in our jurisdiction. Our court structure. What is the hierarchy of courts in Canada? Anybody? Just you don't have to be correct. Nkiru, do you want to try?
For this one.
Sorry, can you be a bit louder?
Okay. I think I'll take a pass for this one.
Oh, okay. Thank you. No problem at all. Anyone else? Farhana, do you want to try?
I'm just gonna go on a guess though.
It's fine.
So on the top, we'll obviously have the Supreme Court of Canada.
Correct.
And maybe the Federal Court of Appeal and Provincial Court of Appeal and Provincial Superior Courts and lower tribunals.
Okay, thank you very much, Farhana. So first of all, we have Section 96 courts. They are called that they call Section 96 courts because they have been established pursuant to Section 96 of the Constitution. So in the hierarchy of courts, we have the Supreme Court at the highest level. We have the as Farhana mentioned, we have the provincial Court of Appeal, or territorial Court of Appeal, or the Federal Court of Appeal, or the Court Martial Court of Appeal. They are all on the same level. So the Supreme Court at the top, the Provincial Court of Appeal, the Federal Court of Appeal, and Territorial Court of Appeal, and the Court Martial Court of Appeal, they are all on the same level. So they are all appeal courts. Then we also, beneath it, we have the Superior Court, whether established by the province or by the territory or by the federal government. So Superior Court, Court of Appeal, and the Supreme Court, and various. We can have various Court of Appeal, whether by the province or by the territory or by the federal government, and we also have provincial courts, provincial superior courts, whether established by the territory or by the province or by the federal. Then we also have the provincial courts. These are separate from the provincial superior courts. Provincial courts are not superior courts. They are just courts established by the provinces. You will see that in Canada, the difference, it has a peculiar court system, in the sense that the courts, the Provincial Court of Appeal, for example, and the Provincial Superior Court are established by the provinces, but the judges are appointed by the federal government, and their salaries are also paid by the federal government. The Constitution stated that the provinces are responsible for the constitution, maintenance, and organization of the courts, of both the Superior Court and the Court of Appeal, but the salaries and the appointment of this court are done by the by the federal government. Quite interesting there. And the Supreme Court as well is established by the federal government. So what are the cases that go to Supreme Court? Is there every kind of case that can go to the Supreme Court? We'll be looking at that as well. We also be touching on judicial appointments. I mentioned earlier how the judges are appointed. So what are the nuances in that regard? There are a lot of discussions around that, and that this article will be touching a bit on part of it. So it's also judicial. There are issues around appointments into the judiciary, that it is political, for example, and a number of other issues as well. So we'll also be going into details in that regard. Judicial independence, what does it mean? What are the components of judicial independence? What does it mean for the judiciary to be independent? Areas that you'll be looking at is appointments, financial security, and how they also structure their courts. We also see that these areas of financial security, administrative independence, and what have you, they have institutional perspective as well as individual perspective. So we'll be looking at this in details as well. We'll also be reviewing this article on judicial diversity and judicial independence. What is the relationship between judicial diversity and judicial independence? We'll also be looking at that as well. Quickly, we'll go to statutory interpretation. For laymen, when you read the statutes, it's written in English. I can understand it, but that's not necessarily the case in most cases. As we'll see, there are various nuances to be considered in interpreting a statute. what are the approaches to interpreting a statute. So we look at the original approach, the living tree approach, and the modern rule to interpretation of statute. What does the modern rule, what does it mean? What does, what's it called? What approach should be adopted in interpreting statutes? We'll also be reviewing the articles of shared meaning as formulated in R and Daust. I mentioned earlier, I think under chapter 2, that Canada is a mixed law or is a bi-jura jurisdiction, in the sense that the both civil code and the common law operates in Canada, and there is a constitutional requirement that federal laws should be written both in English and in French, and in certain provinces as well. In Manitoba, for example, the laws are required, and I think in Nova Scotia and as well as New Brunswick, if I'm correct, the laws are required to be written in both French and in English as well. We all know that when you write something in different languages, it can convey different meaning in the two languages, based on the social and cultural and other various factors of the two languages. So as the Constitution requires that laws should be written in both English and in French, if there is a conflict between the two interpretations, how is it resolved? So this article speaks to that as well. So we'll be examining the case of R and Daust. Also, the second article is what I just mentioned, is a constitutional inconsistency in legislation. How is that resolved? And finally, on chapter 10, constraints on legislative and administrative action. So we've talked about a number of administrative decisions and or administrative board, and administrative bodies, they play a major role, a significant role in the Canadian setup. I mentioned immigration, for example, which most immigrants will have related with in one way or the other. So their decision, how is it subject to judicial review in the first place? How is it reviewed by the courts? What standard of review is applied? What is justiciability? For example, what is the role of judicial review in a democratic society? I mentioned earlier how the parliament is the supreme authority in terms of enactment of law, and how they are seen as the representative of the public or of the populace, because they are the ones that have been elected, have been voted for by the public. But when the parliament takes any action, is it subject to judicial review? And how does this relate to the concept of parliamentary supremacy? Because you didn't elect the judges, unelected judges, they are reviewing and validating or invalidating the decision of the parliament. How does that work or how is that contradiction? How is it resolved in the context of the Canadian society? We'll also be looking at that. We'll also be looking at the standard of review. When in reviewing this administrative decision, how is it reviewed by the judiciary? The concept of difference, or what role does it play in that framework? So we'll be reading a number of articles. I think there are about 5 articles in this regard. We'll also be examining the case of Dunsmuir which has now been overtaken by the case of Vavilov. We'll be looking at those cases in details and see how to understand the standard of review adopted by the judiciary in reviewing executive and legislative action. When should they adopt a particular standard of review, and why should they adopt one or not and not the other in the standard of review? We'll be looking at that as well. Areas in the course of the classes as well. We have the manuals notes that is available for purchase on our website. We'll also be developing key points, because we've been talking over the last 2 hours over different aspects of the course, and these are just short overview that we have provided. So in an exam scenario, you might not have the time to go through the courses, so we'll be providing short notes or key points, if you like. It will also be available for sale, which sort of guides you to in answering the question. Because if you have the textbook, if you have the the materials, it is quite voluminous, right? And in exam scenario, usually these days you have 4 hours. In the August exam, the NCA provided 4 hours to answer the questions, and you can have a question whereby it can take you about 30 to 45 minutes to even dissect the question and understand what the NCA is talking about. Because again, it's important to answer the question rightly, right? So the instruction will always tell you that if you should pay attention to the question. If you write general principle and you don't apply the principles to the facts of the case, you are not going to be scored extra marks for doing that. So to understand the question itself might take you 30 minutes, and before you know it, your time is gone. So what the notes or quick reference or key points does for you is to summarize the principle, the applicable case, and you can just make expound on that in your own exam. So I will take questions if we have, and I will look forward to seeing all of you in our next classes.